has taken note of the fact that Mr. Nakatobi no longer seeks interim relief. He filed a supplementary head over the weekend, I think, in which he makes it clear that in light of the other parties' submissions that they were abandoning the interim relief, as I understand it, he can speak for himself if I've got it wrong, and that they would seek final relief, as does the other parties. And we prepared our argument on that, since getting that note on that basis. So I intended, in fact, when I addressed the court, to explain that I would be dealing with the substantive challenges and the nature of the decision and so forth across the board, and Mr. Rosenberg would deal with other aspects of the matter. So we're prepared to deal with all the applicants. And with respect, I would submit that we would be prejudiced to have to make an argument and then have to make it again, and have Mr. Nakatobi make his argument when he seeks effectively the same relief only on Thursday. But we would request that all the applicants go first, just as the truck drivers argue their case as well, and we then know, as the respondents, what case it is we need to meet, because I think one of the aspects in this matter, which I'm sure everyone is aware of, is that it's been a very, very large example of moving targets and shifting goalposts.
Yeah.
And we need to know, in order to properly represent our clients' contentions, what precisely is being argued against us in the various applications. So we would respectfully ask that all of the applicants, including the truck drivers, go first, and then the minister's representatives argue second, as the court pleases.
My lady, I don't wish to interrupt, but might I say something on Mr. Jamie, which I think is in support of him? Is it convenient if I'm...
Yes, you may.
Thank you, my lady.
My
lady, I'm not sure whether you whether your clerk forwarded to you, because we, like the bench, were mindful of the concern about finishing. And so what we did was we sat down with all of the council across all 5 matters, even if you include the truckers, and we agreed on a timetable which would allow us to finish, in fact, by the end of the 3rd day, possibly at worst by the 4th day. But I don't know if you received that timetable.
What we've received is your note on oral, on your oral argument that you'll present. I don't know whether, and we've received it literally 15 minutes. We're supposed to commence. I didn't receive any other document from my clerk.
No, it was an email sent last week. I'm told my connection is spotty. Can you give me 1 moment to change onto LAN? If you just give me 1 moment.
Yeah, that's fine.
My lady, I apologize. I will sort out the connection in a moment, but there was an email that was sent to your clerk last week on the 4th of April, in which we set out the proposed timetable in detail with the applicants to go first. Could I perhaps talk you through it if it's convenient?
Yeah, is it uploaded onto case lines?
No, but I will have it uploaded immediately.
Yeah, because if it's uploaded onto case lines, we would have seen it.
Yes, your clerk said she'd forwarded it to you, but perhaps there was an error of communication. Let me have it uploaded immediately.
I do not think the rest of the bench also
if you give me 1 moment, I'll get my attorneys to upload it.
Judge Malindi, did you have regard to it?
Thanks. It's being uploaded as we speak. Perhaps we could just wait for a moment.
I just want to find out from the other judges. Judge Malindi?
My sister did not have regard to that timetable because I have not received it.
So, yeah. Judge Mota?
The same is true for me.
Okay,
my sister.
thank you.
I do apologise for that, judges. I'd asked for it to be forwarded to you, but with hindsight, we should have uploaded it to case lines as well.
I think that the court was in recess. It's the first day of the term today, so to have just sent through stuff via email perhaps was a bigger challenge, because we had worked on the matters, on the case line profiles of the matters.
Yes.
And it would have been brought to our attention had it been on case lines.
Yes.
Yeah.
It's being uploaded as we speak. Perhaps you would just give me a moment for it to be uploaded, and then I can talk you through it.
Right. But Applicant Toby did not seem to have a problem with this matter being dealt with on Thursday. That's still the position.
Yes, no, we have no problem either way, my lady. I'm happy with Mr. Badlander's position. He will articulate it in a second. Yeah. We are also happy with your leadership's position.
Okay, thank you.
Let me be clear, my lady, we also have no difficulty. We're not trying to make life more difficult for the bench. We were trying to make life easier, which is the reason that we did the timetable. But we are, of course, in your ladyship's hands. And the email made clear, which will be uploaded in a moment, that it was all subject to the court's direction.
Yes. You see, Mr. Butlander, the challenge that we've had is we've had regard to what was uploaded onto case lines. And I take the point that you sent something through via email, but we've also had regard to the joint practice notes that have been uploaded onto case lines. And that's what informed our decision as the bench, because we are responsible to ensure that we get through the entire 3 applications with the allocated time.
Yes, my lady, let me reiterate, we are very much in your hands. We're not trying to be difficult, we're trying to help. Could I just take you to the relevant page on case lines, and then we will leave it in the hands of the court. I don't propose to argue the matter of a timetable is the matter in the hands of the court. It's at 061-1. And my junior has directed you there.
All right, I've had regard to the document where I suppose we would have to discuss it as the bench because we're only seeing it now. Thank you, Mr. Butlander.
Yes.
Okay. So anything else that you would want to,
thank you, my lady,
to add? Sorry, Mr. Butlander, is there anything else you would want to add to this timetable?
Not from my side. Thank you, my lady.
Okay, thank you.
No, my lady, not from me. Not from me.
All right, thank you, Mr. Jamie.
Sorry, Justice. I understand Mr. Butlander has just given you the suggested timetable without. I'm not criticising him, but he hasn't perhaps referred to or emphasised the changed nature of the relief that is sought by ZIF. And if I might be so as impertinent as to inquire, when you gave us your initial views and proposed direction that the ZIF matter be heard on Thursday, was the court aware of the fact that the relief had changed to now?
We were aware of it, yes.
Oh, you were? We
were aware of it, exactly.
Our difficulty remains, Justice, that it made sense to hear ZIF separately when they were seeking different substantive relief. In other words, an interdict pending a review. When everyone else was seeking a review, it would have been conceptually perhaps difficult to morph all those into one. Now that they seek a review, there is no reason we would, with the greatest respect, submit to have their application heard separately on Thursday. It would mean we wouldn't necessarily have to argue our case twice, and that may well lead to us not finishing on Thursday.
No, we will ensure that that all parties do finish in time for the allocated time that's been allocated. But we have to have regard to the fact that we have 3 substantive applications that we have to deal with this week. And you argue the point that the other matter where they now seek a review, it's already before the court. The papers have not changed. Not so. They've applied for an amendment.
They've abandoned the interdict and they seek the same relief as HSF and COMSA. And
that's not their papers as it stands.
Those are the papers they propose arguing on, Justice.
Yeah, I understand, but it's not the papers as it stands on case lines currently.
The abandonment of the interdict.
No, the notice of motion that they've issued. But Mr. Jamie, I don't think we have to get into that argument right now. You've indicated your stance as the respondents. You would not want to argue a matter twice, given the stance of a change in stance taken by the applicant in the other matter, and we've heard you on that. But I need to consult the rest of the bench on it. I'm not sitting alone in these proceedings.
As the court pleases.
Yes.
I'm sorry if I've been too insistent. I apologize.
No, I've taken your position and I'll take it into account. Can I just indicate the other matter? This is the African Amnesty matter. That matter, when we went through the papers, we are of the view that we're going to deal with this particular matter, Mr. Chitando, on Friday. Do you have any issue to take with this matter being dealt with on Friday?
My lady, I've got no issues at all with that. In fact, it is particularly helpful because we received supplementary heads of argument from the respondents, and it was something that we're going to discuss. But I think putting it to Friday does help both the respondents and I. Okay.
Thank you, Mr. Chitando. Mr. Durant?
As it pleases, my lady, I have no objection or qualms with your directive.
Okay. Your matter will be dealt with then on Friday, which is the 14th of April. We'll see you at 10 o'clock. You're welcome to remain online if you have the time to spare. If not, you excuse until. Justice Malinji, can you confirm that? That's what we've agreed.
That's what we agreed indeed. And if I may just ask Mr. Jamie, whether Mr. Jamie, is your proposal that all applicants move their applications and all respondents in the order of their applications then respond to all applicants at once without dividing the matters into 3 separate hearings?
It is indeed, thank you, Justice Malindi, that is precisely my request and proposal. Although the matters are brought separately, apart from the truck drivers application, which is a discrete application saying that the entire conception and execution of these regimes was from the get-go unlawful, all the others are attacks. So HSF, COMSA, ZIF are attacks on primarily, and of course Amity, where I don't act for the minister. Those 4 applications are attacks on the coming to an end of the ZEP, to use as neutral language as I can. And the grounds for those 4 applications are interwoven. Conceptually and legally, there was a distinction with ZIF because they sought different relief. They sought an interdict. They no longer seek that. So the result of them no longer seeking that is that the minister, in the 2 teams for the minister, myself and Mr. Durance, we are faced with 4 applications with interwoven factual, in fact, largely common cause factual, but interwoven legal submissions. And I submit it would be conceptually difficult for us, but also for the court to deal with the matters on successive days. It would be fragmented, it would be unnecessary, it would be unnecessarily time consuming because we'd have to rehash the arguments 3 times. And conceptually, with the greatest of respect, but also very importantly, from the point of view of my clients in those 3 matters, apart from amity where I don't act for the minister, we would be prejudiced were we not inconvenience in terms of time and just convenience, but inconvenience in the legal sense, were we to have to rehash arguments over and over again. So we do ask, and also we are entitled to know how the arguments fit together and what concessions are made in different cases in the different arguments before we deal with our response. And for that reason, we submit that we should be entitled, and the court should allow us to hear all the applicants who challenge the minister's decision, and then we respond as a whole and in one go.
Yes.
And that is my request. Thank you very much for clarifying that, Justice.
Mr. Chitando, save for the fact that you wish to consider supplementary heads, would you be amenable to Mr. Jamie's suggestion, or do you still insist that hearing your application separately is still more convenient to your client?
Thank you, Justice. I just would like to deal with what Mr. Jamie said. I think it may actually assist him, considering what the understanding, I believe, on WhatsApp messages I've been exchanging with Mr. Durance. He'll speak for himself, I'm sure, after I've spoken.
Yeah. If parties may be conscious of the fact that we are not dealing with the real merits of their applications, but the convenience of disposing of this matter as quickly as possible. So there are 2 practical propositions made. The one that the court had already prepared as a directive for today, and what has arisen today. So it's a question of convenience, not the merits.
Yes, but I understand. I think I was actually going to speak on the issue of convenience, you see, because I believe the point that Mr. Jamie is making is that he would like to hear all of the applicants that are challenging his case. And I understand where he's coming from. He would like to hear everyone that is against him. But in my case, it is Mr. Durance. So Mr. Durance is going to have will be the party with the benefit of hearing all of the applicants. If he so chooses, if he's going to sit as Justice Collis has said throughout the hearing until Friday. But Mr. Durance and I, from what I've gathered, we are happy for Friday. Mr. Durance will hear all the applicants. The ZIF, you'll hear Mr. Budlander and his team, and then respond, and then hear me, obviously, on Friday before him. And then he would have the opportunity on Friday to respond to everyone. So I think the concerns that Mr. Jamie has with the hearing on Thursday with ZIF is not the concern that he has with us. It's not with us, you see. So my view, it would be practical for us to be here on Friday, with myself and Mr. Durance having the benefit of the week to hear the others.
Thank you, my sister.
Mr. Marta, Judge Marta.
I have nothing to add at this stage, except that perhaps this might necessitate a bit of an adjournment for us to recalibrate the matter and think our way forward.
Okay. But for the African amity matter, are you amenable for that matter to be dealt with on Friday?
Precisely. I think it doesn't fit the exact bill with these other matters, so I think it would be prudent to deal with it on Friday and perhaps just refashion these other ones into a different format.
Okay. All right. So,
could I just ask one question? So our position is still the same. If the court feels it's more convenient to hear us on Thursday, we'll be here on Thursday. If we're to be heard now, we will be heard now. But the one technical issue which your ladyship raised is whether we should now amend formally if there is an objection to the fact that we are changing our position to final relief, whether it is now required of us to put in an amendment. Maybe the government advocates can answer us, because it's really up to their client's position about whether there is any prejudice in the note we filed or what the position is.
Would you want a response from them now, Advocate Nkaitobe?
At some stage, my lady, once you have given a directive about what's going to happen, at some stage we just need some clarity.
Okay. I was just responding to the argument that Mr. Jamie had placed before the court at the time when he argued for these matters to be dealt with from today onwards until Thursday, as the parties propose. So I think I suggest that what we could do at this juncture is we can take a short adjournment, and then we can inform the parties once we are ready about our directive for the hearing of the matters.
As you please.
So shall we take a 15-minute adjournment for that?
As the court pleases.
As the court pleases.
As the court pleases.
Okay. I don't know. Plugging in. I don't know. Are these judges coming to me or what? I couldn't say to them.
No, but remember yesterday, you guys agreed that when there's a thing, they'll come here.
Okay. So,
Excuse me, there's someone who hasn't muted their mic so we can hear you.
Oh, yeah, it was the judge. I've just muted her. Thank you, Jamie.
Pleasure.
Thank you, Tapua. Are we ready to start?
We are, my lady. May I call the matters into record?
Yes, just make sure the other judges are online. Thank you.
Thank you, my lady. In the High Court of South Africa, Gauteng Division, Pretoria, today is the 11th of April 2023. This is a full bench third court motion heard via Microsoft Teams before the Honorable Justice Collis J, before the Honorable Justice Malindi J, and the Honorable Justice Mota AJ. The cases are as follows. It is case number 32323 of 2022. That is the Helen Suzman Foundation versus the Minister of Home Affairs and Director General of the Department of Home Affairs. Case number 006386 of 2022. It's Vinderin Margarite and another versus Minister of Home Affairs and others. Case number 51735 of 2021. It's African Amity NPC and others versus Minister of Home Affairs and others.